Good morning. Thank you for joining Privacy Chat. I'm Nancy, Communications Director at the Future of Privacy Forum. This morning, we are chatting about the latest in state privacy legislation. Joining us is FPF Counsel for Legislative Outreach and Analysis, Sanderson. Before I kick it over to Jules, just a few upcoming events to mention. Join us next week for AI Out Loud on the 14th. And for our next Digital Data Flows class on AI and governance, on May 20th. You can register for both events on fpf.org. With that, I'll hand it over to Jules.
Super, and thank you, Nancy. And do join us for the training on AI if you are somebody who needs to know a bit more about how the technology works. This is not a law and policy class. There's a lot of that. Great programs that are out there. What there aren't, or at least we thought this would be something special to add, is programs that help those of us who are more of the law and policy types, who we're not the math majors, but who need to understand a bit more about the statistics, the tech, the data flows behind ad tech, behind AI, behind the identification. So as Nancy said, the next training classes are coming up. May 20th for the AI one. The EdTech one sold out. So I imagine AI will as well. So check that out. One other item that I'll mention before Polly and I start, I just wanted to take a moment to recognize and say how much so many in the privacy community are shocked and taken aback and just moved by the news of the loss of Kurt Wimmer. Kurt, as many of you know, was a co-lead of the security and privacy practice at Covington here in DC. His clients were, the blue chip of companies, long list. He had been the general counsel of a leading news organization, in addition to being a real leader on privacy and data protection, was a real leader on First Amendment issues. But beyond his career as a smart, real expert and leader professionally, one of the nicest human beings around. Law firms are competitive places. Firms compete for business. There's billing. There's stress. Kurt somehow had this warmth, this calmness to everybody, not just the peers or the big shots or companies that he was working with or doing business. It didn't matter who you were. Kurt was one of the people who was there to be a friend, was there to help, there to just have a relationship with you in a very human way, and really a reminder to all of us to treasure those relationships, because Kurt really did. Also a very eclectic guy, had very interesting and broad music tastes. And if you remember, there was this very strange period in Washington where the Juggalos, the fans of what was the band? Something Suicide, I don't know, some sort of controversial band. And they dress in some strange ways, and they were going to have a very peaceful event in Washington. And because a few people, of course, in a huge group of fans, had been at some point arrested or tied to some gang activity, the whole fan group, which was thousands and thousands of people, because of the fact that they, painted their faces and so forth, were being treated as if they were some sort of, criminal gang. And Kurt really spoke up for them. And his photography was really wonderful. He was an expert photographer as well. So to so many of you who know Kurt, our sympathies, all of us are remembering him, and hopefully there'll be time to have more proper memorials. And to those of you who don't, just wanted to share a little bit about him. Okay, Polly, thanks for joining me on. I got to tell you, I'd like to think I'm a decent sort of manager or, a good CEO to our employees, but I do have some bad habits. And one is that I think all of our staff are brilliant and available and ready at any time to just be smart and wise and be out there. And you know what? They are. But I know that it'd be nice to give people sometimes a little bit of notice. But Polly, yesterday, when we said, who should join today? I said, there's a lot of state activity. Polly, will you join? So you'll see how she's super on top of things, but this is with very little, advance notice from the boss. Get online, stream to thousands of people. But you know what? You are one of the handful of people around the country who is really deeply following, analyzing, and sort of helping keep a lot of our stakeholders apprised, helping state legislators stay up and helping them as they need to get educated about how to draft privacy legislation. We would prefer they be doing this on the federal level. Please, Biden administration, let's get around to this. We do need a national privacy law. We're one of the few countries in the world, certainly one of the few democratic countries, that doesn't have a comprehensive bill. We are long overdue. Every day that we don't, new business models develop that are going to be harder to rein in and harder to rein back. We need it. But until then, the states will be states, and they'll legislate and hopefully set the tone. So, Polly, give us a picture of what's going on. It's so hard for people, even as a former state legislator who has some, sense of the process and so forth, as I served many years ago, it's really hard to know what matters, which are moving. There's so much activity. What's your snapshot? Which states are important now to look at because they are seriously moving bills, and what do those bills look like?
Yeah, well, I think one of the first tips that I would give to anyone who is interested in tracking closely is to look at the legislative sessions and just when those begin and end. And we have a few states coming up in April that the legislative session is going to end, and that includes Washington State, which is a very important state in terms of privacy legislation. The Washington Privacy Act is been introduced for the third time. It has recently undergone some very significant amendments, as expected, in the House Judiciary Committee, which could potentially kill the bill. A limited private right of action was added, even though there was no monetary relief available. The fear is that when you open the door to private right of action on the state level, then lots of different types of private rights of actions could arise in all different states. And so, whether or not someone's open to considering private right of action on the federal level, at the state level, it's just one of those things that really gets industry concerned. But aside from that, the opt-out right was expanded to include a global opt-out provision, which would enable individuals to express their intent to opt out via a browser or a plugin globally, rather than having to go site by site. And that's something that Consumer Reports has been advocating for quite successfully in California. It's also a provision of the Senate version of the Florida bill.
Florida. And we heard, I think, Senator Wyden in the federal level say it was going to be a priority for him to add. So it seems like this notion, which sort of, popped up as a follow-on to the efforts years ago to create a do not track right, and where the Attorney General somehow leveraged the California legislation to put this out, it's really influencing other states, and Consumer Reports and Ashken Soltani and others are, raising it. I urge people to take a look at the GitHub, where the folks who are working on one model, right? Anyone can create a global privacy control. What makes it global, and who recognizes it as the one that needs to be recognized, as opposed to, any individual symbol that I might create myself. But the one that is out there today is one you might want to take a look at. You can get involved and try to, propose changes or so forth. I'll post the link to the GitHub. That group has taken it to the W3C. I don't know where that stands, but that's, I think, the place to look for those who are hearing Polly say that, for better or worse, if you're a fan or not, this notion of a sort of universal do not sell symbol, universal I won't call it do not track because it's about sale, not tracking, but a technical signal. So you want to follow this because you may be living with this in the near future at the federal level as well as the state level.
Yeah, and it is a very key point that, what are you opting out of? And so in this case, it is opting out of sale. And I mean, that kind of brings us on to a broader theme of a lot of the legislation that we've seen introduced. it's lots of the legislation, like for instance, in the California legislation, it's a bundle of rights provided to individuals, opt-outs for sales, heavy focus on sales and individuals being able to express a choice about whether information is sold or not. And so that's really, it's very liberal for the companies. They can still collect information, they can still process it how they wish. But then, individuals would then have limited rights over the ability to, stop sales if they opt out of sales. But it's interesting that the global opt-out has not been removed from the Florida privacy legislation because, it was recently heavily amended, the Senate version of the bill. The private right of action was removed. We saw EPIC and a group of consumer organizations writing a letter in opposition to the removal of that private right of action. So, same as previous years, private rights of action and enforcement mechanisms are a huge battleground for state legislation. But the Florida legislation, it doesn't include risk assessments. It's got a very narrow definition of personal information, in my opinion. It doesn't include identifiable information, only identified information, which I find to be quite narrow, especially as technology becomes more advanced.
It's more like Nevada, where maybe Nevada is even more limited, because Nevada, it's actually got to be some very explicit personal information. Here, I guess identified. So I guess if you use, right, I mean, what are we really talking about, right? We're talking about the cookies and the IP addresses, typically when we, when many of these debates, hit the floor with legislators. So identified might allow a company to say, yes, this could be identified, but I have internal processes and I'm just reading, cookies. So it may end up being a little closer to where Nevada is, where the technical data doesn't get captured.
Yeah. And, I've been watching closely the way that personal information is defined, because I just think it has such a huge influence on the scope of the bill, like what's in, what's out. And, we've seen, increasingly narrow definitions of personal information, in my opinion, with like very broad exclusions. So for instance, there was a Utah bill which failed. And, I always feel a bit uncomfortable saying that it was similar to the Washington Privacy Act. It had a very similar framework to the Washington Privacy Act. It had risk assessments. It distinguished between controllers and processors. It had this concept of pseudonymous information. But rather than just excluding pseudonymous information from access rights and correction rights and deletion rights, but then still subjecting it to risk assessments and data security requirements and opt-outs like the Washington Privacy Act does, the Utah bill excluded pseudonymous data from the scope of...
So hold this notion for a second of pseudonymous data, because it's been my great frustration. Let's start on the European side, right? The European GDPR sweeps wide, and GDPR, defines pseudonymous as being a safeguard, but being personal. And previous, and maybe still, although I guess maybe not, but previously, well pseudonymized information, right? Pseudonymization is a process. It's not a legal category. It's a process where you replace direct identifiers with alternatives. You may have secondary items, indirect identifiers in the database. But the question is, can you meet the Breyer test? Can you do something serious where, although technically it is possible that the data could be unmasked, you've taken steps, key coding, one-way hashing, tight retention. Khaled El-Imam and I and colleagues did a paper a couple of years ago calling for a category called protected pseudonymous data. This is maybe pharma key-coded data in the hand of the researcher who really has no way of identifying the data sets. He doesn't have, she doesn't have a huge data set. It's hashed one way, but The pharma company could, but maybe they won't. Maybe it's not legal to do so, right? And the Breyer case in the European Court of Justice did leave open the notion in a case that was about IP addresses that because legally the government agencies who were the players at issue here could, because they had legal authority to find out who was behind an IP address, the data was personal. But what if the additional data kept separately is not available and is actually restricted? So the UK ICO, which previously would have permitted such data, as well as a number of other countries, frankly, in Europe, is updating guidance. They announced that they're going to go sort of stage by stage and take input. The NHS is deeply dependent on anonymous data, doesn't have some of the legal authorities that if some of the data was deemed personal would limit some of their activity. I'm hoping they will update the previous guidance and say something useful. Obviously, they're not, a European regulator anymore. But I think just to get back to where we started, we have a huge opportunity in the US to actually define carefully with the legal and the technical experts what is and what isn't personal, because it is not a black line. You are in, you are out. It is a spectrum.
Yeah.
Safeguards matter. How do you, what's the point of safeguards if they don't matter? Safeguards can ensure that the risk is low. How low, right? So Kelsey Finch on our team is leading an effort at FPF since we now have language. We have the CCPA, CPRA language. What exactly does it mean? And what does the FTC believe personal information means? Anyway, I'll stop there, but stay tuned for more from FPF on defining personal information in the US and in the States.
Yeah, and it really is a continuum. I really like describing it as identifiability on a spectrum. And that's why I find it, interesting that sometimes people define personal information as not including identifiable information. I just think that that's a little bit too narrow. But yeah, pseudonymous information is interesting, especially, under California law, it's not treated in the same explicit way that the newly enacted Virginia law does, which specifically excludes pseudonymous information from most of the rights.
California mentions pseudonymous data, but then doesn't really do much with it. Is that right?
Yeah, it does. It introduces the term, and it's similar to the way that they introduced the term for profiling, and then they punt it to the AG to kind of further define and to work out like what should we do about opt-outs for profiling, and like what kind of disclosure should be required, like what is meaningful information about the logic involved for an automated decision system or something. But
mentions dynamic IP addresses, which are maybe a good example, right? You might have it in your possession, it won't be necessarily there again, assuming it hasn't been logged with other information that would identify. It might be identified in the hands of the ISP, but what if you don't have access to it? Is it a relative question, or is it an absolute question when we look at identification? So anyway, important.
And who can identify it? Could it be someone on the street? Could it be someone with technical expertise, the company? So how are we judging it? There are lots of questions. I think final point I want to make about pseudonymous information is that even though California doesn't seem to do much with the definition, in practice, pseudonymous data would still be excluded from the access, correction, deletion requirements because it doesn't rise to the level that would enable a person to authenticate and verify an individual for the purpose of those rights, which means, and it would actually create a privacy risk if you're requiring companies to actually hold information in a more identifiable format. And so that's just another interesting kind of nuance of that in terms of pseudonymous information. But yeah, so I mean, in terms of main models that we're seeing, yes.
Well, let's hit the other states. You mentioned Florida, California. We talked Washington Privacy Act. Oklahoma, there was a bill moving there. That's closed for now, it seems, right? Yeah. And then did we touch New York yet?
We haven't touched New York yet. New York, their legislative session, it ends in June. similar to Colorado.
But they often come back. I mean, I had many miserable, months where, I thought I was done. It's a part-time job. You got to make a living. I thought I was done in June. And then, we came back to do more COVID or COVID. So I don't know what their plans are, but in any case, but in theory, the clock is ticking.
Yeah, and no, you're right. They will probably come back. I don't think that right now they're really focused a lot on moving privacy bills. There have been over 40 privacy bills introduced in New York this session. The governor even included privacy language in his budget. That's been removed now.
And that was a big deal because, again, 40 bills, members drop in bills. Again, I had a lot of bills that never went anywhere, but I'd reintroduce them every year because then I would announce that, I proposed this bill. It showed what I stood for as a, legislator, and the fact that, it wasn't ever going to pass. But when the governor pops it in the budget, right? But it appears that I think for our international watchers, the governor of New York, who was a big celebrity for his strong COVID leadership, is now in the doghouse because of many stories of harassment of women staff, and so is on the potentially is being impeached, is being investigated. It appears that language is not in the budget process anymore. But there was one bill that Senator Kevin Thomas, who's been one of the leaders on the issue, perhaps the Senate side leader, who's the biggest champion and who chairs the relevant committee, right? It's the Consumer Protection Committee. And he had a bill that was focused on intermediaries, fiduciary liability, right? That was a different path. We haven't seen that yet this year.
Yes, and so surprisingly, like Senator Thomas has actually not introduced privacy legislation yet, and so we are expecting to see that type of legislation come back around. But whether or not the concept of fiduciary duties is removed from the bill, is still an open question because it hasn't been introduced yet. But it's
Julie Cohen's critique of state and federal privacy legislation, Professor Julie Cohen at Georgetown.
Yes, and she was very critical of the idea of fiduciary duties, as is the incoming FTC Commissioner, Lena Khan. She wrote the skeptical take on fiduciary duties. And so that's who we've actually now got in a very powerful position at the Federal Trade Commission. So it's just an interesting data point. I think that the idea of fiduciary duties is it's difficult because I think that you need to be more specific in the US. I think it's to do with the US legal system. When you actually, lots of the professors that are suggesting fiduciary duties, I think they have like a kind of an English background or in terms of their legal studies, because the idea of like fiduciary duties kind of makes sense like automatically in my head because it's quite fleshed out under English common law. But in the US, I think you need to be more specific. And when I think about how fiduciary duties or just duties of loyalty in general could maybe be actionized in the US, I see like dark patterns. Like that's so specific. This is a specific instance of manipulative design. You shouldn't have a dark pattern in an opt-out for a sale. Like that's what the recent CCPA regulations have now banned dark patterns, and that's catching on. And so I think that there are ways that these types of concepts could be incorporated into US privacy legislation, but just in very specific ways. It's just a completely different legal system.
Yeah, and I do recommend people read Professor Jack Bialkin, who's a legal superstar at Harvard, who with Jonathan Zittrain has done some writing about this. But I think I agree with Julie Cohen, who makes an interesting point, which is we have a well-developed understanding of fiduciary when it comes to things like your lawyer represents you, they can have a conflict, they have certain obligations. Your doctor, we have certain areas where we understand that a doctor cannot violate confidentiality, has to, can't recommend the procedure that is the most expensive, that will make, him or her the most money. It's got to be what is in your best interest. When it comes to what's a search engine or what is a transaction with a big company, what is their fiduciary responsibility? I mean, these are business relationships. They're making money. What would it mean for them to be fiduciaries? It feels like it's punting. We don't actually know the boundaries of what it means for them to act only in your interest. Can they make money? Can they not sell data? Can they not recommend things to you? We kind of need to bang that out. That's the point of this legislation. And it feels sort of like a punt, and then we'll figure it out with like rules. So anyway, what are any other states? I think we have the sense that it may not appear again in Kevin Thomas's legislation. We'll see what is proposed, but I think our understanding is that that may not, be part of the future. And are those the key states right now? Any other states doing anything interesting?
Well, yeah, before I move on to that, just very briefly, the Data Fairness Act was introduced in New York, and that does include the concepts of care, loyalty, and confidentiality. But a similar bill in Washington State, the People's Privacy Act, it didn't really gather that much steam. I don't think that legislators are really understanding like what is meant by fiduciary. I mean, some of the language says that, organizations would have to put the interests of individuals before themselves. It's interesting. I'm not sure how it's going to catch on, but the states that I'm watching right now are Florida, watching very, very closely with the upcoming end of session, and also Colorado. Colorado very recently introduced a Washington Privacy Act style bill. It distinguishes between controllers and processors. It includes risk assessments. The legislative session ends in June, so we've got a bit of time, and so I'm expecting a few hearings to probably come.
And the Attorney General there, who's pretty involved in this legislation, is a very sophisticated, with all due respect to attorneys general, there are some buffoons out there, with great apologies, who are just political, actors. Weiser, the California AG, former dean of the University of Colorado Boulder Law School, former senior official in the Obama administration, a real expert on tech and law. And so optimistic that he will, since he and his team have been playing a role, have a thoughtful input into that process.
Yeah, and it has strong obligations for companies like transparency requirements, purpose specification, data minimization, the duty to avoid secondary uses. And I think one interesting thing about the Colorado legislation is that it doesn't include a private right of action, but it would be enforceable not only by the Attorney General, but also district attorneys. And so that would really it would create an environment where the Attorney General, so in California, the Attorney General said they could only bring 3 cases a year. It really widens the amount of cases that could be brought if district attorneys can then also bring cases, even though there's not a private right of action. So I just thought that was an interesting nuance when it comes to Colorado. And another state I'm watching closely is Illinois, because there are a lot of BIPA amendments that have been introduced that would weaken BIPA, considering that this is such a liability issue for so many companies. It's just something to have on the radar.
BIPA, for those of you, right, is the biometrics act that has led to hundreds of millions of dollars of sort of fines against Facebook, and lots of litigation against any company that has sort of photo tagging and stuff like that. So there's been a little bit of a backlash, but on the other hand, a lot of consumer groups are very, very happy to see how aggressively it's been used. Let's close with one theme. A lot of the bills are sort of opt-in, opt-out, but there is a theme, and Consumer Reports has been a champion of this, and Sherrod Brown in the Senate, that this whole opt-in, opt-out stuff is very confusing, and we really need a different model. You want to say something about that? CR's, certainly raising that in a lot of states.
Yeah, absolutely. There's a whole body of academic research which, outlines how opt-in, opt-out, consumer control, privacy self-management approaches to privacy legislation are so ineffective. They've been debunked, basically. So moving beyond the opt-in, opt-out, what comes next? We've spoken about fiduciary duties, that's very confusing. So one thing that Consumer Reports has suggested, they've unveiled their Model State Privacy Act in February, late February. And so they focus on very strong data minimization provisions, kind of similar to the Colorado bill, and prohibitions on secondary uses and sharing and downstream sharing. Non-discrimination is a very, very important part of that bill. And I think that might be one of the kind of table stakes issues to getting federal legislation passed as well. I think, the link between privacy legislation and anti-discrimination, it cannot be underestimated. So I think it's an interesting alternative approach.
Yeah, a lot of us on the federal level are focusing on the fact that you have, Cantwell as the new chair, and the fact that she put out legislation, and then Wicker, the former chair, now the minority ranking leader. And there are obviously some differences between those two bills, but we should note that Sherrod Brown and many of the civil society groups aren't even necessarily signed on to the Democratic sort of version, and are advocating for something more in line with the Consumer Reports argument, where let's rule things in or out and not heavily rely on opt-in, opt-out. A quick shout out to our friend Mac McCullough, Macy's. Mac, dear friend, useful, helpful, thoughtful colleague who always has valuable input, but here has critical input. He reminds us that the Juggalos are the fans of the Insane Clown Posse. That is the group. I'm not a super big music person, but I do remember reading about the news. For those of you who weren't at the beginning of this stream, the Insane Clown Posse had these fans called the Juggalos. They were being called gangsters. And Kurt was one of the folks who both photographed them. I'll post a link to his Instagram account, which has just phenomenal pictures, and, made the case that just because you have some bad eggs in a fan group, the whole notion of labeling all fans, who are dressing a certain way as, a threatening group is a bad idea. I remember when the Juggalos came and had a big march in Washington, it was like, oh my God, there's going to be some invasion, there's some insurrection going on. And it was a very polite and calm and, uneventful but entertaining experience. Okay. Isn't she awesome? That was like with zero preparation. So thank you for the quick update, Polly. Remember, May 20th, our AI training class. Please sign up. Register if you would like us to come to your company remotely, of course, and do a bespoke class so you can ask all kinds of questions. We'll do that as well. May 13th, book club, Privacy at the Margins. Privacy really matters when it is affecting some of the marginalized classes. So really a book that's getting a lot of attention. University of Colorado Boulder held a full-day program with the author and other academics going through different portions of the book. So it's really a book having a lot of impact. And then AI Out Loud, our AI team is looking at, with a prominent collection of panelists, including our friend Ann Toth, trust lead at Alexa. What does it mean to make sure that the smart assistants don't serve only certain voices, certain communities? What does it mean to be represented in the data when these smart speakers are supposed to be, working equally well for all of us and not leaving anybody out? Thanks, everybody. We'll see you again next Friday. Thanks in the background, Jackson and Nancy, for helping set things up, and have a great week, everybody.
Thank you.